Or where they were.
That's why Tammy. You hear
That's why, yeah.
I can't get you.
Let's do this. We're on record. DDC. Miss Lisa, where are the females? Pardon me? Yeah. Okay. Looks like 3 females.
Yes. I'm not sure. I know Lisa just went over there and picked up the files. Okay, so I think that's all we was missing. Y'all know was the female files.
Yes.
That's what she came to get. You got all the files and everything up there?
Yep, except for the females.
Yeah, sure. You got some.
Is there an interview on that? I didn't bring that ants, but it's right.
Girl, which case is Attorney Krause on?
WHAP. That is number 1 on page 2.
That's the only. Oh, did we get Mr.
Mr. Blake Wright?
Yeah.
I mean, Mr. Wright Blake?
Yeah, what was his first name? It was hyphenated.
No, his first name is who? Oh, Bell. It was Bell, but we have no Bell.
Yeah, it was. Yeah, it was.
Arthur something Bell.
Yeah, it was.
Excuse me,
Yep, and we.
I'll let you know. I'll be away from my
Pardon
desk.
me?
I'll be away from my desk for a minute. Okay. Let you know.
Go for a minute. I'm hoping to start. We're just waiting for DDC.
No.
DDC? DDC?
Yes, yes, there's no view. I can't, I mean, I hear you, can you hear me?
Can you hear me, DDC? DDC, can you hear me? I'm not sure if they're muted.
You know, make it better.
No. Counselor Kraus, can you hear me?
I can, Judge.
Okay, so we'll just see. We can hear you. Okay, DDC? I can't, if you can speak, if you can hear me.
Hello.
Hello, DDC, good afternoon, sir. Do you have a copy of the list?
No view.
We are not on mute.
You, there's no picture.
Oh, there is no picture. Let's see. Well, we can see you, but you can't see us. Great. Let's see. I'm gonna disconnect and see by calling you again. Is that okay? Let's try this again. Disconnect. Call them. See if this happens. DDC,
Yes.
can you see us?
Yes.
Okay. You have a copy of the list? Do you have a copy of the list, DDC?
Copy.
Okay. Can you bring Mr. Bohack? He's number 1 on page 2.
Andrew James Borak.
Okay. Mr. Bohack, this is Magistrate Chartea. We are recording. Your case number is 24060554001. You have retained counsel. Go ahead, counsel, please.
Yes, good afternoon, Your Honor. Sarah Kraus, P81830. I'm appearing on behalf of Andrew Bohack, who is present. We would waive the reading of the complaint and warrant at this time, Judge.
Thank you, ma'am. I'm going to enter a plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Taylor. Mr. Bohack, some bond conditions. First of all, no assaultive or combative behavior on your part. You're not to possess any firearms or any other dangerous weapons. No drinking of any alcoholic beverages, and no driving of any automobiles without a valid driver's license. Do you understand that, sir?
Yes, Your Honor.
Okay. That being said, Counsel Ragnan, okay, you're here for the people. Go ahead,
Yes,
please.
good afternoon, Your Honor. Samuel A. Ragnan, P23-157 on behalf of the people. Your Honor, even though the defendant is charged with malicious destruction of police property with extensive damage and also assaultive behavior, people are going to ask for a $25,000 personal bond in this matter, Your Honor.
Okay. And Counsel Cross, no objection?
Judge, I have no objection to the personal bond. I do wish to address the court on permission to travel. Mr. Bohack was here on business when this event was alleged to have occurred. He is originally from Massachusetts. His family has retained counsel on his behalf, being the Crips and Silver Law Office. I do not believe he is a risk to not return to the state of Michigan. He is employed full-time. He does come to Michigan for work purposes and has for quite some time. So I'm asking for him to have permission to return home and to travel back and forth from Michigan to Massachusetts.
Counsel
No,
Ragnan?
No objection, Your Honor.
Okay. All right. He's allowed to go to Massachusetts. I got to spell it. M-A-C-H. I think so.
M-A-S-S, Massachusetts. Yeah.
Yeah, well. I know. Hmm. Let's just try. See, on the investigator's report, he's listed as residing there. But in his attorney paperwork, oh no, listed Medford. Yep, Medford. Mr. Bohack, please spell Massachusetts for me.
Massachusetts.
All right, probably I didn't get it right, but it's good enough. All right, $25,000 personal bond allowed to go out of state. Which is MA. Okay. All right. Anything else, councils?
No,
Nothing
thank you,
further today,
Judge.
Your Honor.
Thank you. That concludes
day,
his
Ms.
agreement.
Have a great day, everyone.
You as well.
You too.
Aaron Lee Patton.
Mr. Patman, I'm Magistrate John Passer. You're here on a criminal matter. Excuse me, case number is 24060-55201. You have an attorney. Go ahead, counsel.
Family Ragland for the people. Oh, sorry, Mr. Bird, you're up.
Yes, Aaron. Brandon Bird on behalf of Aaron Patton. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Enter plea of not guilty. Court dates are November 26, 2024. Probable cause conference followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Giles. Mr. Patman, while this case is pending, you're not to possess, purchase, sell any illegal controlled substances. Do you understand all that, sir?
Yes, Your Honor.
Thank you. All right. Counsel Ragnan, he has metropolitan ties. Charges are not assaultive. I see some prior convictions. But go ahead, Esteban, please.
Well, he does have, he was sentenced 11/10/23 to for being without permission to 18 months probation. So he is on probation. He's got an A1 2016 unarmed robbery in 7 and a receiving and stealing motor vehicle in 22. So, Your Honor, we believe that a $50,000 personal bond would be appropriate, plus a tether. And the reason for the tether, Your Honor, is that on 6/2/22, he was sentenced for 2 years probation for receiving and concealing a motor vehicle. That was supposed to be off 11/10/23. But what happened is that he's had 4 violations of probation where he failed to show up. And in addition, he's had on 6/10/23, he had a tether $1,000 10% for failure to show up as well on another matter. So I'm asking for a tether with home arrest. Thank you.
Question.
25.
Is there a warrant out for his arrest right now?
I don't know, Your Honor, if there is, because he is on probation. So there's a violation, but there isn't any warrant that I saw that's out there today.
All right, let me ask DDC. DDC,
Yes, Your Honor.
yes, can you tell me, does Mr. Patton have any holds?
But I'm not on probation. I'm not on probation or parole.
Oh, it's
Mr. Patton, let DDC let us know. Appreciate it. Thank you. DDC, does Mr. Patton have any holds?
No.
Okay, thank you. Go ahead, Council Bird.
Yep, there's no holds, and that's probably because, like my client says, he's not on probation, Your Honor. 55-year-old lifelong resident indicates to us that he's living with his mother right now. He is employed, but his hours vary. He'd be unable to afford any amount of bond in this matter. These are non-assaultive allegations, Your Honor, respectfully. We're just gonna ask for that personal bond with no tether. He understands that he has to show up to court, and is willing to do so.
Okay, thank you. Heard the representation both sides, started off with personal bond basis, no holds, even though he has some prior convictions, 2022, 2016. One of them is assaultive. The DDC says no holds, so we're gonna give him a personal bond. However, understand, Mr. Patton, if you violate any of the bond conditions, don't show up for court. Understand the next time there'll be a monetary bond. You understand that, sir?
Yes, Your Honor.
All right, again, bond is $50,000 personal bond.
Thank you, Your Honor.
Thank
Your
you.
Honor.
What's your name, sir?
Gary LaRue Llewellyn.
Say your name again, sir?
Devontae Gary LaRue Llewellyn.
Ah. Okay. Mr. Llewellyn, sir, this is Magistrate Chathaster. You hear a criminal matter. You are defendant one in this case, 2406055-301, sir. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of Dante Llewellyn. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you. I'm gonna enter plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Jefferson. Mr. Llewellyn, while this case is pending, you are not to have any contact with the Denise Barton. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. Do you understand those bond conditions, sir?
Yes, Your Honor.
Okay. All right, Counsel Ragland, go ahead, Esteban, please.
People are asking for $10,000 cash surety bond. If you're able to post a bond, we're asking for tethered home arrest. Very assaultive matter. The mother of, a woman who pulled into a driveway where he and his new girlfriend were living to get some of her belongings. She had a witness in the car. The defendant came running out there, pulled two guns on her and held them towards her and said, "You almost killed my daughter on the bike." The witness and the defendant said no, they waited until she crossed the driveway. With that, the co-defendant, who we're going to get to here shortly, Miss Smith, she came over and grabbed a gun from him as well and started yelling at them also. So, Your Honor, it was assaultive. It's holding guns at these people. And there are witnesses that this is what this defendant and the other defendant did. There also is but he has an extent. He has a record, Your Honor, and 21021. He was on for weapons charges. I'm not sure. Let's see. He had a 52721. He assault with a deadly weapon, discharged firearm from a vehicle, 2 felony firearms cases. I believe that he was found guilty of. He was charged here with a HAB 3, so 11310 fleeing from a police officer, fourth, and 11310 attempt receiving and concealing a motor vehicle. The other charges I mentioned, the AWU and the felony firearms, it just says we're bound over. I get a chance to follow up on them. Thank you.
Are you saying that he has a pending case?
It says open, but I don't, it's from 21 and I didn't get a chance.
Okay,
I imagine it's not.
thank you. Go ahead, Counsel Bird.
Yes, Your Honor. Respectfully, if we could just stick with what's in the complaint, with these non-assaultive allegations, our office doesn't see any open cases or hasn't been provided that information. But 33-year-old lifelong resident, Your Honor, lives with his wife, his kids, and he was forthcoming about his criminal background before we even read it to him. Unfortunately, he's been a butcher now for a couple of years, but unfortunately, below the 200% poverty guidelines, any amount of bond is going to be unaffordable for my client at this point. He is a diabetic and on high blood pressure medication. If we can mark his file medical, it'd be greatly appreciated. He hasn't received his medicine, and it could potentially be dangerous for him in the county jail without receiving his medicine. Now, it's not witnesses. We have one person that's claiming to be a witness that came with her friend, but my client has a side of the story too. And my client indicates to us that he never pointed a gun at anybody. He never handled a gun with anybody. Yes, the neighbors did almost hit their child, and they did say something to those neighbors about it, in which they've been having difficulties with these neighbors since they had to have a talk with them about peeing in their pool. So this is more than just an issue, one issue. This is an issue that in which they had to talk to these neighbors multiple times who have reason to not tell the truth on my client at this point. But luckily, as stated in the report, that they're moving out, so it's going to be no problem with no contact. They don't have a problem with not contact them, and don't really even want to deal with him at all. He just wants to put this matter behind him in this case, Your Honor. So respectfully, we're going to ask this court for a personal bond in this matter. My client knows he has to show up in court. We haven't been presented with any KP's history. He understands that he has a criminal background, and having a weapon could potentially put him in prison, and that's not a place he wants to be, especially with the two children that he's helped raising at this moment, Your Honor. So with the children that he's helped raising at this moment, Your Honor. So respectfully, we're asking for a personal bond in this matter.
Thank you. Counsel Byrd, did you say he was working or not working?
He is working, Your Honor. He is working. He's going to lose his job if he can't get out, and he's going to lose his ability to take care of his family if he can't get out of jail. That's why he understands what's at risk here and would do nothing to mess that up, Your Honor.
Thank you. Court's heard the representations, both sides. This particular matter, court uses clear, convincing evidence standard to entertain, if it's going to entertain a monetary bond. Started off with a personal bond basis. In this particular matter, the charges are serious enough, but allegedly, if not pointing, having firearms out and then making threats. Okay. Specifically, supposedly, quote, "I'll shoot your face off if you hit my daughter," unquote. And supposing that, and not only that, the firearms were described. I don't know if they're exact, but more or less that there was 2 firearms. Court finds that there is enough, but court also takes into consideration that he is a diabetic. DDC, can you mark his file medical? And in this particular matter, the court is going to adopt the recommendation, $10,000 cash surety, along with a GPS tether for work only. And because it's unaffordable, we are going to give him another court date for this Monday, which will be November 18, 2024. It's going to be in front of Judge McConicle, 9 o'clock, or Judge Williams, who will look at the bond amount and bond conditions. Understand that, Mr. Flewellen?
Yes, ma'am.
Okay, thank you, sir. You can step aside.
I'm just respectfully, Your Honor, respectfully, okay, permission to speak.
Okay, something new?
I can't say that it's new, but it might have been.
Go ahead if you want to place it on the record.
Thank you, Your Honor, but respectfully, like, if we did take these allegations in the report to be true, And this is an incident in which supposedly somebody believed that their daughter was going to be hit. It's not like he went out into the community to use weapons, Your Honor. The thing about it is, I'm not saying any situation is right to handle it, but right now those complaining witnesses moved out. They moved out. They're gone. The report says that they're gone. So it's not going to be a problem with those complaining witnesses. He hasn't proven to be a threat within the community. And if we do send him into Detroit Detention Center and he doesn't get out and he loses his job, that means we're destroying the family. And I understand it's your job to protect the community, but right now, this was supposedly, allegedly between two parties, and one of those parties are out of the situation, which we don't have any capious history on him not appearing to court on that. So when it comes to flight risk, we don't have that capious history. When it comes to threat to the community, or if it's more a threat to the complaining witness isn't even around that situation anymore. Where my client, to have a threat posed to him. Just
Finish?
asking. I mean, I am, Your Honor.
Thank you. Has it been confirmed that the complaints have left?
It was confirmed in the report when they said they were picking up their things because they moved out.
That's true.
Counselor Ragnan, what were you
Yeah.
saying? Did you say something?
No, I just said, I did say that in the report, and of course, Mr. Bird is saying with.
That they moved out?
It didn't say he moved out, it just said she was there to pick up her items, and then this is what happened, so I don't believe.
So they were there to pick up their items, nothing to indicate that they were completely moved out. Well, everything's in the record, okay? It's gonna say as is, but, Council Council Bird, you did put it on the record. Thank you.
Well, Your Honor.
Thank you, Mr. Thank you, Mr. What?
I just want to mention, and I think to be clear, clarification here, because I may have misspoke. They were there to pick up her items because they had left or moved out. I believe that is what was said. The witness stage, if I could just confirm it, because I don't want to misspeak here.
Okay, I missed that. All right, so if they moved out already, they picked it up, okay? I have no problem doing a personal bond, but a GPS tether does stand.
I have no problem with that, just to make sure, Your Honor, okay?
No objection, Your Honor.
$10,000 personal bond, but a GPS tether work only. That means you do not get another court date, Mr. Llewellyn. Nobody has paying money for you to get out of jail.
Thank you, Your Honor.
Thank you. What's your name, sir?
The office Gordon Thomas Jr.
Mr. Thomas, this magistrate at Chartwell. Good afternoon. You hear a criminal matter, case number 24058-42501. Sir, you have an attorney. Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of the office Thomas Jr. My client waives his right to the formal reading, was advised his constitutional rights and stand mute.
Thank you. I'm going to enter plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Sabri. Mr. Thomas, while this case is pending, you are not to go back to the Goulburn residence. Do you understand that, sir?
Yes, ma'am.
Council Rag and Council Byrd, this is from January 2022. I see that he has local ties, charges not assaulted. Go ahead, Council Ragnan.
Well, then we're just gonna ask for $50,000 personal bond in this matter since of the age of the situation. I think that would be appropriate, Your Honor. Thank you.
All right, bond in this case is gonna be 50, thank you. Bond in this case is gonna be $50,000 personal bond. And Council Byrd, if Council Ragnan, it proposes personal bond, okay, the court's gonna assume that you have no objection to the personal bond.
Okay,
So $50,000 personal bond.
Last one,
safe assumption, Your Honor.
last one, Mr. Byrd.
Yes, because there's female.
Oh, it's two copies. Okay.
You want it?
No.
Okay. Sir, what's your name?
Richard Quintile Winston.
To Winston, this magistrate at Charlotte. You hear a criminal matter, case number 2406052001. You have an attorney. Go ahead, counsel. 15 minutes. That's no.
Yes, Your Honor. Brandon Byrd on behalf of Richard Winston, my client, waived his right to the formal reading, was advised his constitutional rights, will stand mute.
I'm gonna enter a plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by a preliminary examination, December 3rd, 2024. Both matters are in front of Judge Taylor. Mr. Winston, bond conditions, you're not to possess any type of ammunition of any kind, and you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
Okay. Counsel Ragnan, this is from June 2023, more than a year ago. I see that he has prior conviction from 2013. Go ahead, Esteban, please.
Well, Your Honor, we're gonna ask for a $50,000 personal bond in this matter as well, because of the time.
Okay, bond in this case is gonna be $50,000 personal bond. Again, assuming that Counsel Byrd is not objecting.
Safe assumption, yes, Your Honor.
Thank you. All right, Mr. Winston, bond is $50,000 personal bond. Nobody has to pay any money for you to get out of jail.
Yes, ma'am.
You can step aside, sir. What's your name, sir?
Brandon Jones.
Jones, magistrate at Chattanooga, your criminal matter, case number 2406055701, sir. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Yes, Your Honor. Brandon Byrd on behalf of Brandon Jones. My client waives his right to formal reading, was advised his constitutional rights, will stand mute.
Thank you. I'm gonna enter a plea of not guilty. Court dates are November 26, 2024. Probable cause conference, followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Robbins. Mr. Jones, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes.
Okay. That being said, the charge is non-assaultive. He has metropolitan ties. Counsel Ragnan, go ahead, Esteban, please.
Well, Your Honor, people are asking for a $10,000 personal bond in this matter. And it's interesting, maybe you can give me some clarification. We have this case, Jones, Brandon, CCW, and then you go over to the second page and there is a, I'm sorry.
Case. It's the same case.
Same case, I thought. Okay, yeah, just $10,000 personal bond.
Thank you. All right, bond in this case is gonna be $10,000 personal. Counsel Byrd is not objecting. All right, Mr. Jones, nobody has to pay money for you to get out of jail. Just go to court. Thank you, sir.
Okay, thank you.
What's your name, sir? The gentleman at DDC, what's your name?
D'Angelo Reed.
All right, Mr. Reed, this magistrate at Chadasser, you're here on a criminal matter. Case number is 240-60-55901, sir. You have an attorney. Go ahead, counsel.
D'Angelo Reed.
Yes, sir.
Yes, Your Honor. Brandon Bird on behalf of D'Angelo Reed. My client waives his right to the formal reading and divides his constitutional rights and will stand mute.
Thank you. I'm gonna enter plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by a preliminary examination, December 3rd, 2024. Both matters are in front of Judge Robbins. Mr. Reed, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
That being said, the charge is non-assaultive. I see that he has local ties. Counsel Ragnan, go ahead, Esteban.
People are asking for a $10,000 personal bond, Your Honor.
In this case, bond, I'm gonna adopt the recommendation. Bond is $10,000, personal bond. Nobody has to pay any money for you to get out of jail. This court is assuming that counsel Bird is not objecting. He always argues for personal bond, especially in these type of cases. All right, thank you, Mr. Reed. You can step
Never
aside.
heard him change it. Never have ever heard him change it. No, nothing I've been here. Which is fine.
Gentlemen at DDC, what's your name, sir?
William Spikes.
Mr. Spikes, this is Magistrate at Charter. Good afternoon. You're here on a criminal matter. Case number 240-60-56101, sir. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of William Spikes. My client waives his right to the formal reading, was advised his constitutional rights and will stand mute.
I'm gonna enter plea of not guilty. The charge is not assaultive. He has local ties. Counsel Ragnan, go ahead, Esteban, please.
People are asking for a $5,000 personal bond, Your Honor, no priors. Thank you.
Okay. Bond in this case is gonna be $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Mr. Spikes, you can step aside. The court is assuming that Counsel Bird is not objecting to the personal bond.
Your Honor, I must say.
Oh,
it's
I'm
been
sorry.
nice
I
not-
thought I gave the court dates. November 26, 2024, probable cause conference, followed by a preliminary examination. December 3rd, 2024, both matters are in front of Judge Robbins.
I was gonna say, it's kind of nice not having to listen to Mr. Bird talk again. That was a joke.
Well-
Mr. Bird.
Just
was
for
just
that,
a
I got you on the next one, Sam.
That was just a
Okay. All right, the young man in orange, what's your name, sir?
My name is Dwayne Lewis.
Mr. Lewis, I'm Magistrate at Charter. Good afternoon. You're here on a criminal matter, case number 240-60-56001, sir. You have an attorney. Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of Dwayne Lewis. My client waived his right to the formal reading, was advised his constitutional rights and will stand mute. No objection to a personal bond.
Thank you. I'm gonna enter plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by a preliminary examination, December 3rd, 2024. Both matters are in front of Judge Giles. Mr. Lewis, while this case is pending, there's no assaultive or combative behavior on your part. You understand that?
Yes, ma'am.
Okay.
Yes.
All right. That being said, he has local ties. He has a prior conviction, non-assaultive. Counsel Ragnan, go ahead, Esteban, please.
People are asking for a $15,000 personal bond. Thank you.
Okay. That being said, Mr. Lewis, your bond is $15,000 personal bond. Nobody has to pay any money for you to get out of jail. Your attorney already indicated that he doesn't oppose personal bond. Thank you. You can step aside, sir.
I'm done.
Yes.
All right,
Yes,
thank
sir.
you.
Yes, sir. What's your name, sir?
Cyrus.
I'm sorry, what's your full name again?
East Hodges.
Oh, Hodges. Right. Oh, yeah.
Do you have a middle name, sir?
Henry, Marquise Henry Hodges.
Oh, okay. Mr. Hodges, this is Magistrate at Jump there. Good afternoon. Case number is 24060555501, sir. You have an attorney? Go ahead, counsel.
Yes, Your Honor. Brandon Bird on behalf of Marquise Hodges. My client waived his right to the formal reading, was advised his constitutional rights and will stand mute.
Thank you. I'm gonna enter a plea of not guilty. Court dates are November. Court dates are November 26, 2024, probable cause conference followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Jefferson. All right, Mr. Hodges. All right. Couple of bond conditions. Let's see. First of all, there's no drinking of any alcoholic beverages. 2, you're not to have any contact with a Papa Fay. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, Your Honor.
I see why the charge is assaultive. He has prior conviction, assaultive, 2020. Local ties. This is from December 2023. Go ahead, Counsel Ragnan.
People are asking for $100,000 cash surety bond, Your Honor. If he's able to post bond, we're asking for a tether with home arrest. A very serious matter. The defendant ordered an Uber ride to a location. The complaining witness picked him up. The defendant got in the car. He was swearing and arguing with the driver to the point the driver pulled into a gas station and told him he needed to get out of the car. With that, they got into more of an argument. The defendant pulled out a knife and threatened him. When he saw the knife, the complaining witness ran away. The defendant got in the vehicle and drove the vehicle and left. The defendant admitted that he did this. He admitted he drove the car and that he threatened to fight him, became irate and threatened to fight him. And now there is obviously evidence. The green light video has the whole thing from the gas station on what happened. There's also the evidence of him ordering an Uber in his name and so on. So there's a lot of evidence, but we think this is a danger. He's a danger to the public, but the carjacking is a very serious offense. This is a HAB 3, and I'm going to ask for $100,000 cash surety, tether, house arrest.
Thank you. Counsel Bird, go ahead, please.
47-year-old lifelong resident of Michigan, Your Honor. Indicates to us that he has 5 children, lives with his wife and 2 children, Your Honor. Not on probation and parole, no pending cases. If he did know about this, if this matter was charged, he would have turned himself in. He actually came in off of a traffic stop, Your Honor. So it's not because he picked up any new charge. Indicates to us that he's not on probation and parole and doesn't have any pending cases. He does maintenance. He's a janitor. Works about 50 to 60 hours a week. Suffers from hypertension, Your Honor. He has received his medication. But if we could just make sure that continues, it'd be greatly appreciated. I do understand he is a habitual third offender, Your Honor. It looks like his last incident stemmed back in 2020, but I haven't heard of any capious history due to that matter. So when it comes to flight, I don't believe my client to be a flight. He has went roughly almost a year now, over a year now, since the date was in, well, a year, yeah, almost a year now. Sorry. Since this offense happened, we don't have any indication that there has been any new charges brought against my client. Besides the traffic stop, we don't have any indication that he has even have police contact in that matter. I do understand these are very assaultive allegations, but he has shown for the past year that he could stay out of jail, not pick up any charges, be in the community without being a threat to the community. And respectfully, we're going to potentially ask this court for a personal bond. If this court's not inclined to a personal bond, then a reasonable or low 10% bond seems fit by the court.
Okay. Court uses clear and convincing evidence standard when it's entertaining a monetary bond. We started off with a personal bond basis. We don't know Mr. Hodges's behavior from the date of the incident until now. We just don't have that information. Whether he has been in contact with police, whether he has not, we don't know, one way or another.
I haven't, but I've been serving on youth ministry.
Okay, Mr. Hodges, you don't need to say anything, sir, because everything is being recorded. Okay. So anything you say, it could be used against you later on in this case. So with that being said, DDC, can you mark Mr. Hodges' file medical, please? The court does find that Mr. Hodges is a danger. Okay. Whether he's a flight risk or not, that this court doesn't know. But a danger, yes, he is. So we're going to adopt the recommendation, the $100,000 cash surety. We're not going to put him on a GPS tether, okay, because he's going to get an unaffordable bond redetermination day, simply because this amount of money is unaffordable. Is that correct, Council Byrd?
Definitely.
Okay. So that means he's going to get a court date this Monday, which is November 18, 2024, 36 District Court, 36 District Court, 9 o'clock in front of Judge McConaughey or Judge Williams, who will look at the bond amount and bond conditions. So, Mr. Hodges, you're going to get another court date this Monday. Do you understand that? Okay. Thank you, sir. You can step aside. Sir, what's your name?
Good evening, Your Honor. Alonzo Paisley.
Thank you, Mr. Paisley. I'm Magistrate Charte. You hear criminal matter. Your good afternoon. Case number 240-6055-601. You have, excuse me, you have an attorney, sir. Go ahead, Council Byrd.
Yes, Your Honor. Brandon Byrd on behalf of Hunley Paisley, my client waives his right to the formal reading, was advised his constitutional right, so stand mute.
Thank you. I'm gonna enter a plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Sabri. Mr. Paisley, bond conditions, you're not to have any contact with a Michelle Anderson. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. You're not to possess any ammunition of any kind. You are not to go back to the Vinewood residence where it appears that you and the complaint appear to reside together. Do you understand those bond conditions, sir?
Yes, Your Honor.
Council Reagan, go ahead, Esteban, please.
And people are asking for $100,000 cash surety bond to be able to post. They're asking for a tetherless home arrest. Obviously, you said no contact. Very assaultive matter, Your Honor. The complainant and defendant got into an argument that turned physical. The defendant then placed an unknown firearm to the complainant's head and ordered her and her children, ages 13 and 4, out of the residence. So this was done with children apparently present to the situation. The complainant then went to the neighbor's home and called police, who subsequently came to the residence and arrested him. The EMS was refused. Officers made and gained access to the residence through an unlocked front window because he wouldn't open the door. And they located the defendant hiding there in the kitchen. They didn't find a pistol, but they found a shotgun. Got several felony convictions, a CCW in Third Circuit on October 5th, in October of 2015, and a CCW on December of 2009, and a felony controlled substance on June of 2012. He was convicted, Your Honor, but he's also got pending cases, and which makes this even more disturbing is the complaining witness has had to go through this more than one time because he has a case pending, Your Honor, right now, 42324 bound over for assaulting a police officer. He had a HAB-4 and a domestic violence, the same complaining witness. Jury trial is set for 10/31/24. He's got a 9/21/24. He was arrested for police damaging police property and firehouse property or fireman property. HAB-4 jury trial, same date, 10/31/24.
What are the bonds?
Well, the bond was 50,000 personal on the one from 4/3/24. I don't know what's happened to these since. And on the complaining witness was uncooperative on a DV back on 3/5/24. So, you know, with pending cases, I don't know what's happened to them. I've researched them. This is all I have. But I'm just saying he's in danger, this complaining witness, Your Honor, and putting a gun to someone's head, I think is
Council Ragnan.
Yes.
But I want to know, he has more than one pending case. Is that
Yes.
correct?
Yes.
And one of the cases has the same complaint as in this case.
Yes.
And the one with the same complaint is a bond, a personal bond.
He does in one case, and I don't know about the other.
But the one with the complaint, you know what the bond is? Is that a personal bond?
Yes, it is. $50,000.
Okay, thank you.
So I think
Council Byrd, go ahead.
Hold on 1 second, y'all. I'm just wondering because I'm confused, Your Honor. You said that there was a trial date for 2 trial dates set on the same day for 10/31. That's Halloween. That passed. So are we talking about these same cases where they dismissed or
it shows.
So
Council Ragnan,
Yes.
go ahead and respond.
Well, yeah, I don't know. As I mentioned, it just showed on the report, jury trial set for that day. Then it had a pretrial conference set as well. So I don't know what's happened since then. I wasn't able to find that at the time. And I'm just saying that these cases are still showed as open.
Okay, thank you.
No, under
Council Byrd, go ahead.
765.6A, I think he's entitled, I think a cash bond is necessary for the protection of the complainant. Thank you.
Thank you, Council.
If I could just ask what court they're in, because I'm looking in Third Circuit Court under his name in 3RDCC in the Odyssey, and I don't see those cases. So if we could just get what court is in, do you have a case number, or where's this information coming from?
Comes from PBK, Mr. Byrd. That's what we have. Open cases, that's all.
Your Honor, I don't see any cases in 3rdcc.org when under Mr. Payson's name. And
Okay.
maybe I'm spelling it wrong.
I'm happy to
No,
look.
I was spelling his name wrong. I just want to check to see what's going on with these, Your Honor. You got the case numbers, Mr. Ragg?
I'm trying to look right now, Mr. Byrd. So the case 42124, it says open. I'm looking here. It doesn't give me a case number. Click on his last action on this pre-trial. Well, first of all, a jury trial 10/31/24. And then it said pre-trial after that 10/31/24. The pre-trial instead of a jury trial. So that's what I have. And then I have, as soon as it comes back.
The jury trial set in March. It's set for March.
I apologize. It does say, let me see. Did you find that?
I did. I just looked it up.
It says-
That's for malicious destruction of fire or police property, and I see the resisting or obstructing.
No,
I see the resisting or obstructing. I don't see the other. I don't see the other pending case against the complaining witness, Your Honor. But I do trust you and understand where you get your information from. And I was just trying to figure things out, Mr. Ragnar. So I'm not trying to call you out. I'm just trying to figure out what's going on to better protect my.
I never worry about that with you, Mr. Bird.
Okay. Appreciate it.
Okay.
But
Thank you, Mr. Bird. Go ahead with your argument.
38-year-old lifelong resident in Detroit, Your Honor, has 6 children, 2 grown, who he helped raise. He was living with the complaining witness. Unfortunately, he's gonna have to find somewhere else to go. This is a tactic that the complaining witnesses use for trying to get him out of the home. Now, I understand that they said, pointed at him with, and this is why I don't like, this is why I don't like these reports and to put too much faith in these reports. When we do see that there's evidence against defendants, or the police got evidence, we get a report 2-3 pages long. We get one paragraph in. We get one paragraph in this report. If I have the same report as you all, if you all got a better report, let me know. But we get one paragraph in this report that's not explaining anything. It doesn't explain what the children say. It doesn't have any witnesses statements where I can compare the witnesses statements. And for some reason, there's a reason that some of these reports come up with missing information and other reports come up long. So I believe what's out the report, when we know how reports are wrote and they're a regularly recorded record that's written a certain way, and we start to see things that's outside that's not in those reports, only a few certain reports. I believe it's important to notate that, Your Honor, because a lot of things go wrong. It says they pointed an unknown firearm. You would know a shotgun. You would know a shotgun. A shotgun's big. Shotgun's big. They don't state that this is an unknown rifle, that this is an unknown. It was a big gun. They don't have any of those statements. Said that he pointed a firearm. He pointed a firearm and ordered her and the children to get out. But for some reason, we don't have anything with the children. We don't have any evidence of what the children are saying. We have an unloaded shotgun that was in the basement, lying on the table. So if he really, I understand they're trying to say he was hiding, and the police crawled in this open window to come get him. But if he really wanted to hide a gun, I'm pretty sure it wouldn't be an unloaded shotgun laying on the table and right there in plain sight. So, and it's not even describing, and we have no description of what the firearm is. Unknown firearm. They found no other firearms in the house. My client indicates to us that he wouldn't point a gun at anybody with kids, and he's not pointing guns at anybody because he understands that he's a habitual third offender and he's facing pending charges, and that's almost a guaranteed one-way trip to prison. This is all a story that's made up by the complaining witness, because this is an ongoing issue in which the complaining witness wants my client outside of the house, a house that my client owns. And that's what's going that's what's going on. And I believe that's why we see a lot of things missing out of this report, Your Honor. Because it's easier, excuse me, let me just finish up what I'm saying, Mr. Ragland, and I'll let you go. But it's easier to try and say these things happen when you don't have to prove anything and you don't have any corroborated evidence to prove it. So we leave things out. They believe it makes it easier, but my client has a side of the story too, Your Honor. All he does is need an escort to get his belongings. He does have those other cases. If they are bond conditions to that, then those courts could deal with those bond conditions. But my client is maintaining his innocence in this matter. We don't have any corroborating evidence. We just have a statement from the complaining witness and one paragraph that gives us nothing. It gives us no injury. It gives us no. It gives us no statement. We had 3 people there. We had multiple kids there. We had another person there. We won't have a statement from anybody. Or won't have any evidence what type of firearm it was. So I do believe my client that this is a story made up to get him out of respect. We're going to ask for a personal bond in this matter.
May I just briefly, Your Honor?
Go ahead.
Well, I was just
Very
going to say,
briefly.
there's nothing to made up to get her out of the place. He was putting her out and her kids.
I didn't say her. It's made up to get him outside.
I did not interrupt you, okay? I did not interrupt you. Let me just finish. The other thing is, there was 2 cases are pending. The trials are now in March, as he said. Are 50,000 personal bond on one and a 5,000 personal bond on the other. Okay, so I'm asking for cash bond for this case, Your Honor. I think $100,000 cash is appropriate. Tether house arrest if he's able to post a bond. Thank you.
Thank you.
Thank you. And I never
Court
said to
to the
get her out. I never said to get her out. It was.
Thank you. Thank you, folks. Court to the representations of both sides uses clear and convincing evidence standard when it's entertaining a monetary bond. Started off with personal bond basis. Court sees that in the file that there are 2 cases. Both have some assaultive. One has assaultive behavior. In one, case number is 4210067. Okay, but just based on the allegations in the investigative report and the arguments from both sides, okay, the court does find that Mr. Paisley, he is a danger to the community. So we are going to put him down for $100,000 cash surety. We're not going to put him down for a GPS tether. We are going to let Judge McConicle, because he's going to have a bond redetermination for this Monday, December 18th, 2024, 9 o'clock, or Judge Williams to decide. We'll look at the bond amount and bond conditions to see if he needs to have, for his bond amount to be changed, as well as whether or not he's going to get a GPS tether. So right now, $100,000 cash surety, along with this Monday bond redetermination.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. And I'm not trying to convince you about bond. I just got one quick question, though, Your Honor. When do we get past the point where how do we get past the point where I'm not previous cases and things like that, but where do we get past the point where we just make an allegation about you, have no corroborated evidence, and we give people that much that we give people that much credit?
Okay. Well, Council Board, you know that's a trial issue. So I'm going to leave it at that. Thank you, Mr. Paisley. Just so you know, you got another court date this Monday. Council Board, has everybody else of the males been interviewed?
I believe so, Your Honor.
Okay, thank you. Gentlemen at DDC, what's your name, sir?
Stephen Charles Heath.
Mr. Heath, this magistrate, charge back. You're here on a criminal matter, case number 240-60564.